700 boxes of ballots. Federal agents walked out of a Georgia warehouse with all of them, 5 years after the election those ballots had already decided. Court records unsealed in the case make one thing clear. The FBI wasn't after a person. It was after the vote count itself. So why would federal agents move on a county election office half a decade after the votes were counted, certified, and recounted twice? Who inside the current administration set that in motion? And why has a federal judge now ordered an FBI agent to personally explain, under oath, the sworn statement he used to get the warrant? Stick around, because the answer runs through a lawyer once sanctioned by a court for making false claims about an election, a lawyer who now holds a formal position inside the White House. Start with what's actually documented. On January 28, 2026, FBI agents executed a search warrant at the Fulton County Elections Hub and Operations Center in Union City, Georgia, a facility the county opened in 2023 in the Atlanta metro area to store election records and equipment. The warrant, signed by U.S. Magistrate Judge Catherine Salinas, authorized agents to seize physical ballots, ballot images, tabulator tapes, and voter rolls tied to Fulton County's count in the 2020 presidential election. Court records reviewed by multiple news outlets after the case file was unsealed put the total at roughly 700 boxes of material. This search didn't come out of nowhere. The unsealed filings show the Justice Department had already sued Fulton County in December 2025, seeking the release of those same 2020 election records after the county declined to hand them over voluntarily. When that civil route stalled, prosecutors went for a criminal search warrant instead. The distinction matters, so let's be plain about it. A search warrant is not a charge. No person and no institution has been criminally charged in this investigation. Agents were authorized to collect evidence. Nothing in the warrant let them arrest anyone or establish that a crime happened. What triggered the referral that got this investigation moving? The unsealed affidavit traces it back to Kurt Olson. Olson is a lawyer who worked to challenge the 2020 election results on behalf of Trump-aligned legal efforts in the years after that vote. Courts in Arizona sanctioned him for making false claims about that state's election process, and the Arizona State Bar disciplined him for the same conduct. Olson was appointed anyway by President Trump to a newly created position, Director of Election Security and Integrity, inside the White House. According to the affidavit, it was from that post that he referred the Fulton County matter to federal law enforcement. There's a detail in that affidavit that's easy to skim past, but shouldn't be. The specific claims it cites, missing ballot images, alleged discrepancies in the tabulation record, aren't new. They're the same category of allegations that circulated in the months after the 2020 election, and Georgia's own election oversight system already spent years examining them. The state election board appointed an independent monitor, a firm called Seven Hills Strategies, which spent more than 270 hours inside Fulton County's election operation with full access to observe the process. That review found disorganization and sloppy procedure. It found no evidence of fraud, dishonesty, or intentional wrongdoing. Maybe the clearest precedent here sits inside Fulton County's own election night surveillance footage from State Farm Arena, the counting site at the center of the ballot suitcase claim that helped launch the entire 2020 dispute. 2 election workers, Ruby Freeman and her daughter Shay Moss, were accused at the time of pulling hidden suitcases of illegitimate ballots out from under a table after observers left the room. Investigators from 3 separate law enforcement agencies later reviewed the full, unedited footage. What it actually showed was standard procedure: a secure ballot container being brought back out after a mix-up over whether counting was finished for the night. Georgia's Secretary of State released a report in 2021 stating there was no evidence of fraud in what the video showed. Freeman and Moss were never charged because investigators found they hadn't done anything wrong. The false allegations against them still led to threats and harassment that upended their lives for years afterward. That's the same underlying counting process at the same facility that the new federal affidavit reaches back to question. Both the Seven Hills Strategies review and the State Farm Arena finding are matters of public record, years old, and neither has been overturned by any court. That tension is driving the reaction to this search, and the reaction has been sharp from more than one direction, which is itself notable. Georgia's Secretary of State, Brad Raffensperger, is a Republican who was the target of Trump's own pressure campaign after the 2020 election, including a recorded phone call in which Trump asked him to find enough votes to change the result, a call Raffensperger refused. Asked about this FBI search, Raffensperger did not defend it. He called the investigation a waste of time and tax dollars and urged state leadership to stop, in his words, trying to change the past with baseless and repackaged claims. A Republican elections official describing a Justice Department investigation under a Republican administration in those terms. What strikes us about that? This pushback isn't only coming from the party that lost the argument in 2020. It's coming from the elected Republican who literally refused to alter the count. That stops looking like a simple partisan story, and it's worth sitting with before you decide what side of it you're on. On the county side, the reaction moved beyond words into court filings. Fulton County Commission Chairman Rob Pitts said publicly that he believed the raid targeted his county specifically because, as he put it, he had stood up to what he called Donald Trump's big lie. Then, on February 2nd, a Fulton County commissioner announced the county would sue over the seizure, and on February 4th it did, filing a motion in Georgia's Northern District Federal Court challenging the legality of the warrant and demanding the ballots back. The county's argument is practical as much as legal. Those boxes are county property, needed to satisfy Georgia's own election record retention rules, and officials say holding them in federal custody complicates preparation for this year's midterm elections. The lawsuit produced the detail that makes this story more than a partisan back and forth. County lawyers argued in court that the FBI agent's sworn affidavit, the document a judge relies on to decide whether a search is justified, was misleading. The presiding judge, J.P. Boulay, who was himself appointed to the bench by President Trump, took that argument seriously enough to order a hearing. He's forcing the FBI special agent who wrote the affidavit, identified in court records as Hugh Raymond Evans, to testify under oath about how he characterized the evidence. Judge Boulay also ordered the case docket unsealed for public view, both the county's motions and the warrant affidavit itself. Even Judge Boulay's own language is worth hearing directly, because a sitting federal judge rarely puts it this bluntly. In his written order, he acknowledged, in his words, that the events leading up to this case are, in a variety of ways, unprecedented, and that the seizure in this case was certainly not perfect. Outside the courtroom, prominent election law scholars went further. Rick Hasen, a professor who studies election law at UCLA, told reporters, "I'm not aware of something like this happening ever before," and added that seizing ballots to hunt for fraud is especially dangerous here because Georgia's 2020 results have already been extensively counted, recounted, and investigated. Fulton County's own attorneys used the same word in their filings, calling the warrant unprecedented in American history. The government, for its part, maintains the warrant was properly obtained and lawfully executed. Voting rights groups haven't waited for the courts to weigh in. Democracy Docket, a voting rights-focused outlet, quoted a constitutional law expert calling the search a five-alarm fire for democracy. Derek Klinger, senior counsel at the State Democracy Research Initiative, called it a dramatic escalation in efforts by the current administration to expand federal control over our country's historically state-run election infrastructure. In Washington, Senators Sheldon Whitehouse and Richard Blumenthal formally called for an investigation into what they characterized as the FBI's own conduct during the seizure. Put yourself in the position of a county election worker that Wednesday morning. You show up to a warehouse you've managed for years, and federal agents are there with a warrant for records tied to a vote that was already recounted, audited, and certified. Whatever you believe about 2020, that's not a routine Wednesday. Now, the part that doesn't fit neatly into either side's narrative, this search does have a documented legal basis. A federal magistrate judge reviewed the affidavit and signed the warrant before agents ever entered the building. That's a real judicial check, not something agents did on their own. But a second federal judge has since found the underlying affidavit worth scrutinizing enough to order the agent who wrote it into a courtroom. Both of those things are true at once, and that's precisely why this case is still unresolved rather than settled. This next part will probably draw disagreement from some of you, whichever side you're on. A judge's signature on a warrant answers whether federal agents were legally permitted to search that warehouse in the moment. It doesn't answer whether reopening a 5-year-old, twice-recounted election was a sound use of federal law enforcement, or whether it sets a precedent any future administration, of either party, could use against any county that certified a result it didn't like. You can believe the search was technically lawful and still believe it was the wrong call. Those two positions aren't actually in conflict. So we'll ask you directly, does a valid warrant settle whether this investigation should have happened at all, or is that a separate question entirely? Tell us where you land in the comments. On this one, the replies are going to be worth reading. Where does the case actually stand right now? As of this recording, no charges have been filed against any individual or against Fulton County as an institution. The Justice Department describes this as an active criminal investigation into whether irregularities in the 2020 ballot counting process amounted to violations of federal law. It's not a finished case with a conclusion. Under the law, and under basic fairness, that means nothing and no one connected to this matter should be treated as guilty of anything. An investigation, and the court fight playing out alongside it, is a process for establishing facts, not a verdict. The custody fight has played out in the months since. A retired Georgia Supreme Court justice was brought in by the court to help oversee the hearings on the seized ballots. In early May, Judge Boulay issued his ruling. The Justice Department does not have to return the boxes to Fulton County. But it wasn't a clean win for the government. The judge went out of his way to describe parts of the Justice Department's own case as misleading and troubling, even while allowing federal agents to keep the material for now. Fulton County has the option to appeal that ruling to the 11th Circuit Court of Appeals, and as of the most recent reporting, no appeal has been filed. In July, a separate skirmish broke the county's way. A federal judge quashed a Justice Department subpoena that had sought the names and personal information of Fulton County's 2020 poll workers, the kind of rank-and-file election staff who counted the votes in the first place. And in the most recent development, a federal judge dismissed a separate lawsuit that had tried to stop the administration from using or sharing the sensitive voter data pulled from those seized boxes. So the question of what the government can eventually do with that data still isn't fully settled either. What's still genuinely unknown, and not just glossed over for time, prosecutors haven't publicly detailed which specific federal statute they believe may have been violated, or by whom. No charges have followed the seizure in the roughly 7 months since agents walked out with those boxes. Whether that silence means the investigation is quietly winding down, still gathering evidence, or waiting on the outcome of the ongoing court fights isn't something either side has said publicly. And it's not yet known whether this search is the opening move in a broader inquiry into other counties, or whether Fulton County, already the site of years of 2020-era legal fights, remains the sole focus. Why does this matter now, beyond one county's warehouse? Several election law experts following the case have pointed out that a 5-year-old, already resolved election is an odd place to spend this much federal firepower, unless the real audience isn't 2020 at all. Their concern is 2026, the midterms happening this year, and whether a precedent for federal agents seizing county ballot records becomes a tool either party could reach for the next time a close race doesn't go the way Washington wanted. That concern is itself just a hypothesis, not a documented fact about intent, and we want to be clear about that line. But it's the reason a legal fight over records from an election half a decade in the past is being watched so closely by officials worried about the one happening right now. What we can say with confidence is this: a sitting administration used federal law enforcement to physically seize a county's ballots from an election that independent monitors had already spent years examining and found no fraud in. That happened on a referral from a lawyer with a documented record of making false election claims, the same lawyer this administration chose to place in charge of federal election security. A federal judge has now ordered the FBI agent behind that decision to explain his own sworn statement in open court, and that same judge has already used the words misleading and troubling to describe part of the government's case, even in the ruling that let the government keep the ballots. Whether you find all of that reassuring, alarming, or somewhere in between probably says less about this case than about where you already stood. Either way, it's a live matter in federal court, 7 months in, with no charges and no end date, and we'll be following exactly where it goes next. If you want to check any of this yourself rather than take our word for it, the unsealed warrant, the affidavit, and Fulton County's own court filings are all public federal court records. We'd rather you verify it than just trust a voiceover.